Good morning. This is John Landesman from Cohen Seglias, Palace, Greenhall, and Furman. On the line with me is Marc Cytryn, and we are here to present this webinar for the Washington Building Congress on coronavirus employment law, and it's an update for contractors. We're going to have this for about 1 hour today. And I want to welcome everyone on the line. We're going to go over a broad number of issues. We'll have an agenda. That's one of the next slides coming up. Throughout the presentation, because we have so many people on the call, if there are any questions, we would encourage you to ask questions using the questions box or chat function that is on the GoToWebinar site that you're looking at. So we'll try to take some questions throughout the presentation, but we'll also set aside 10 to 15 minutes at the end of the presentation for questions. And we've been dealing with contractors, and we know that there's a lot of questions on this issue. Our firm, Cohen Seglias, we have offices in Washington, in Philadelphia, New York, primarily the Mid-Atlantic region, and we represent well in excess of 1,000 contractors in any given year. So we're really a law firm designed to represent construction contractors. So without further ado, I will hand it off to Marc, my co-presenter, and he'll jump right into it. Marc?
Good morning, everyone. So as John had mentioned, today we're going to go through a host of different issues related to coronavirus, including new federal laws and other issues that are coming up for contractors really all over the country. And I'll show you just a glimpse of what we'll walk through. So in terms of today's agenda, first we're going to take a look at everybody's new favorite law, the Families First Coronavirus Response Act, and that's a federal law. So it does apply to states all over the nation, and we'll address how it applies to you in particular. And after that, we'll take a look at how unemployment compensation benefits and also claims for workers' compensation benefits are linked to coronavirus and how those will play out in some different circumstances related to the virus. After that, we'll take a look at the WARN Act, which imposes certain requirements when employers make quote unquote plant closings or mass layoffs. And we'll take a look at how each state's law in Virginia, Maryland, and also in the District of Columbia, how those requirements apply to contractors located there. After that, we'll take a look at the CARES Act, which is the new federal stimulus package. And in particular, we'll look at the Paycheck Protection Loan Program, which is very pertinent to a lot of contractors, especially those, and we'll touch upon this, that have less than 500 employees and can be eligible for that program. And last, we'll take a look through some additional FAQs related to coronavirus and how they impact contractors as well. So without further ado, we'll talk about the Families First Coronavirus Response Act. As I mentioned before, this is a federal law, so it applies to all 50 states in the union, and it was first signed into law by President Trump on March 18, 2020. In general, the law requires that all employers that fall under its coverage provide a certain amount of paid sick time and also paid expanded family and medical leave benefits to employees for certain reasons related to coronavirus. Now, the law was signed into, the bill was signed into law on March 18th of 2020, but it did not take effect until April 1st. And it's also scheduled to remain in effect until December 31st of this year. So it is, quote unquote, a temporary law. It's also possible that the federal government could end up extending that time frame if it becomes necessary. One important thing to keep in mind is that the United States Department of Labor just recently, at the end of last week, issued its regulations related to the Families First Coronavirus Response Act. And the U.S. Department of Labor clarified in those regulations that any leave taken before April 1st, even if it was for a qualifying reason under the Families First Coronavirus Response Act, would not require paid benefits under that law. So essentially, anything April 1st forward it must comply with the law, but anything that happened before then does not. So we'll give you a brief overview of who the law applies to, and in particular, it applies to businesses that have 500 or fewer employees. And there's also an exception in the law that talks about how if a business has fewer than 50 employees, they are not required to give paid sick time or paid expanded family and medical leave benefits to their employees if doing so would jeopardize their business. The Department of Labor, in its recently released regulations, has also provided additional guidance on this issue. In particular, they have not established a program or an online portal for employers to submit requests to be exempted, but they have given some guidance as to what employers need to do. And essentially what employers should do if they have less than 50 employees and believe that complying with the paid sick time and paid family and medical leave benefit requirements of the law would impact their business and jeopardize its operations, employers should document the reasons why they believe that would be the case, and they should keep those documents, and they are not required to submit anything at this time to the Department of Labor. So one of the main provisions of the Families First Coronavirus Response Act, and one of the things that employers are most concerned with, is that there's an obvious cash flow issue, and that is the federal government is telling employers and contractors that they have to essentially front the cost of paid sick time and or paid expanded family and medical leave benefits to employees who need time off due to the coronavirus. And for obvious reasons, that's a big concern. What the federal government has done to try to curb that concern is to include a provision in the law which says that any employers who pay out paid sick time or paid expanded and family medical leave benefits under this law are entitled to receive a tax credit when they go to file for their quarterly 941 returns. So that's an important thing to keep in mind. While you may not get the cost reimbursed up front, there is a provision that would allow you to get the cost redeemed when you do file your quarterly returns. And so that's how the government is making sure employers aren't completely out of pocket for those costs. The stimulus bill that was recently introduced and enacted by the federal government, and that's the CARES Act once again, also provides additional details regarding the tax credit process and how they're redeemed. An important thing to keep in mind is that for purposes of these tax credits, they not only include the cost of regular wages or salary that you would pay to an employee who needs to take leave, but they also include the cost of providing those employees with health care benefits like you would usually do under your group plans or health and welfare benefit programs. So you also, when you're submitting for these tax credits, you not only include the cost of wages or salary, but you want to make sure to also include the cost of health care program benefits, because those are also reimbursable to the employer. So going on to the actual components of the Families First Coronavirus Response Act, and I know that I briefly mentioned these earlier, but there are essentially two parts. The first part is paid sick leave, and that means that if an employee needs to take time off for specific reasons that we'll talk about in the next few slides, they're entitled to take essentially the same thing as PTO or sick time that you have under your existing policies, but in a new form under this law. The second component is paid family leave, and that's akin to, and it's really an expansion of, the Federal Family and Medical Leave Act, the FMLA, and some different rules apply to that component of the law that we'll speak about as well. In terms of salary and also benefits, just like the tax credits apply to both of those items, either when an employee takes paid sick time or paid family leave, they're entitled to receive both wages and salary, and also the benefits that they would normally receive during any other time of employment. So with respect to paid sick leave, as I mentioned, this operates as really akin to a PTO or a paid sick time policy, and that you may already have existing, but it applies for specific reasons related to coronavirus. And what employees can get is up to 80 hours or the equivalent of 2 weeks of paid sick time for specific reasons related to coronavirus. An important provision under the law is that any leave or sick time in particular that employees receive under the new law cannot be used to offset what they are already entitled to under your existing PTO or sick time policies or a collective bargaining agreement if you're subject to one. So in other words, if an employee comes to you and says, I need to take a day off from work because I've been infected with coronavirus, you would not be able to force that employee to first use his or her existing PTO that they already had before this law went into effect, and instead they would be entitled to use the additional paid sick time up to 80 hours that is provided to them under this law. And that's important. So anything under this law is in addition to what employees are already entitled to, and you cannot offset what they are entitled to with your existing policies. Now, we'll go over in the next slide the amount of pay that an employee is entitled to, and that amount is different based upon the specific reason or reasons why the employee needs to take leave under the law. So there are 3 reasons that are enumerated under the law where an employee needs to take time off for work due to the coronavirus, and they will receive the equivalent of their full regular pay up to a daily cap of $511. So those 3 reasons primarily relate to when the employee, him or herself, is either sick or needing to quarantine. And once again, it's the employee. So the first reason is if the employee, him or herself, is quarantined or placed in isolation by virtue of a government order. So in other words, if an employee lives in a certain area or becomes infected with coronavirus and is told by the government, either federal, state, or local, that he or she must remain in his or her house and not go to work, that means that that particular employee would qualify for this first reason and would be eligible to receive up to 80 hours of paid sick time at his or her full rate of pay up to a cap of $511 per day. The second scenario in this situation is where an employee has personally been advised by his or her healthcare provider, a physician, or whoever they go to be treated normally, that they need to self-quarantine due to a potential exposure to coronavirus or because they're experiencing symptoms. And this is likely going to be one of the more common scenarios as opposed to the first. And in other words, if an employee comes to you and says, my doctor, I visited my doctor and my doctor examined me and has told me I need to self-quarantine for a period of 14 days because I was potentially exposed to coronavirus, then that employee, if he can give you or she can give you documentation to show that's the case, would qualify for paid sick time at his or her full rate of pay up to $511 per day and up to 80 hours under this second reason. The third reason is and it's similar to the second, is if an employee personally is experiencing actual symptoms related to the coronavirus and has either been diagnosed with the coronavirus or is currently seeking diagnosis and has not yet received the result. That employee, provided they can give you documentation to show that's the case, would also be entitled to up to 80 hours of paid sick time at his or her full rate of pay, up to a cap of $511 per day. So these three reasons are those reasons where the employee would get their full rate of pay as opposed to a reduced amount, which we'll talk about in the next slide. And so the specific reasons why an employee would get less than their full rate of pay are listed in this slide. And as you can see, there are three reasons for this situation as well. In this situation, if the employee falls under any of these three categories, he or she would be entitled to up to 80 hours of paid sick time under the law at a rate of 2/3 of his or her salary, up to a cap of $200 per day. So for purposes of these three reasons, the benefit amount is reduced, and it's less than if the employee, him or herself, is experiencing symptoms or quarantine due to the coronavirus. And the three specific reasons, as you can see, are number one, if the employee comes to you and says, I need to care for someone, usually in their household, who is quarantined by an order of the government or a physician, saying that that individual could be could have been exposed to coronavirus or is experiencing symptoms, the employee in that situation would be entitled to up to 80 hours of paid sick time, up to 2/3 of their current pay, and $200 per day. The second scenario, and this is the one that's likely going to be the most common of the three, is if an employee comes to you and needs to care for his or her child because the child's school is closed or because the child's normal child care arrangements, for instance, a daycare center or some family member who usually cares for the child, is unavailable due to the coronavirus. In that situation, the employee would also be entitled to up to 80 hours of paid sick time at a rate of 2/3 of their pay, up to a cap of $200 per day. The third situation is really a catch-all provision that the federal government decided to include in this law, and it refers to situations in which an employee is experiencing, quote unquote, other substantially similar conditions as specified by the Secretary of Health and Human Services. And now, once again, this is a catch-all provision. The government's guidance on this particular reason is less than crystal clear, but in the event that an employee comes to you and you have, documentation or reason to believe that the employee is either unable to report to work because of a government quarantine or because of an order by his or her physician, likewise, if the employee is unable to report to work because you have documentation to show a child's school is closed or some similar situation, you could use that catch-all provision and give the employee the 80 hours of paid sick time at a 2/3 rate of their salary, up to $200 per day. And that catch-all provision is going to be probably the least likely reason that an employee comes to you with, but it's just important to keep in mind. So in addition to the paid sick time, which is up to 80 hours of paid sick time at a rate of either $511 cap per day or $200 per day, depending on the specific reasons, there's also the paid family leave component of the FFCRA, which gives, once again, I should go back, which once again is really an extension of the already existing Federal Family and Medical Leave Act. And what it does is expands the FMLA to give additional leave to employees who specifically need to be out longer than the first 2 weeks of paid sick time in order to care for a child whose school is closed or whose daycare or child care is unavailable due to coronavirus. And the amount of leave that an employee can get for that is up to 12 weeks total. The first 2 weeks of leave under this expanded family leave provision of the law are paid at the employee's option, as you can see on the slide. And what that means is the employee has the option of saying to you, while I'm out during these first 2 weeks of paid family leave, I want to use my already existing PTO or sick time, if they have any, so they can get paid at their full regular rate of pay. You cannot force them to do that, and they're not required to, but if they want to, they should be given that option. Now, alternatively, if they don't want to use their already existing PTO or sick time to get full pay, what they can do in this situation during the first 2 weeks is use the paid sick time provisions of the law to get 2/3 of their regular rate of pay up to a cap of $200 per day. And then for the remaining 10 weeks, they would get that same amount, the 2/3 of their pay, up to a cap of $200 per day max. I can see there are a few questions on that have been submitted, so I might take a second to just address those before we move on to the next slide. And I could see that Bernie Brill is asking, how many days is the $200 day payment made? And so the answer to that is, when we're looking at paid sick time, the $200 per day payment, and that's the cap. So you'd be talking about 2/3 of the employee's pay up to a cap of $200 per day. And so if the employee only needs leave for 2 weeks, you would pay that amount for up to 80 hours under the paid sick time requirements. If the employee, as set forth in this slide, needs to take paid family leave for additional time, then they could get the $200 up to the $200 day payments for an additional 10 weeks. So it depends upon the reason why the employee needs leave. If you want to look at it in an instance where an employee needs to take time off to care for his or her child because school is closed or the child's daycare is unavailable, in that instance, the way to think about it is the employee could potentially receive up to $200 per day for a total of 12 weeks. And I could also see there's another question from Bernie. Are nonprofits entitled to the paid sick leave for employees? So nonprofits, just like any other employer, are subject to the law. There are some exceptions to that depending on the industry, and we can go into further detail on that specific issue later on. But for now, I'll move on to the next slide. Let me see. So in terms of being eligible for paid family leave, which once again is the expanded version of the FMLA, and it provides employees with up to 12 total weeks of leave where they need to care for their son or daughter who's under 18 years old and whose school has been closed due to coronavirus, or whose child care is no longer available. For that particular part of the law, the employee only needs to have been working for you for at least 30 days. So that's different than other reasons why employees will take FMLA under the ordinary provisions of that law, which prior to the FFCRA going into effect, if an employee, let's say, had a serious health condition or needed surgery, the employee would normally, under the FMLA, need to have been employed by you for at least 12 months and to have worked at least 1,250 hours in the 12 preceding months up to the leave. Now, in this case, once again, the federal government has disposed of those more strict requirements and has said that if an employee is working for you for at least 30 days, that employee is eligible for this expanded paid family leave under the law, once again, to care for a son or daughter under 18 whose school or child care is unavailable. And just an important point to make is that this paid family leave benefit is only available for active employees. In other words, it is not available for employees who have already been furloughed or laid off or are already receiving unemployment compensation benefits due to either one of those situations. And that's because the federal government, for obvious reasons, does not want employees to, quote unquote, double dip into getting both family paid benefits under the Families First Coronavirus Response Act on the one hand, and also unemployment compensation benefits on the other hand. You can see there's another question from Gabriella. So Gabriella is asking, what if an employee is non-exempt and has no PTO? is he entitled to paid leave for the first 10 days and then FMLA for 12 weeks? So if an employee is non-exempt and he is scheduled to work, let's say he or she has not been furloughed or laid off, and he or she is otherwise scheduled to work, that's correct that the employee, even though he or she is hourly, could still be entitled to get paid sick time for the time they would otherwise be scheduled to work during the first 10 days, and also for expanded family medical leave if they need additional time off. So just because an employee is non-exempt or hourly and does not have any PTO remaining, that does not mean that he or she cannot still take leave under the law. And in fact, as long as, once again, the employee has not been furloughed or laid off and is actively employed, he or she would still be able to take leave if they have the need to do so for a qualifying reason. So the answer to that question is yes. So one of the provisions that the Department of Labor has introduced as part of bringing out the Families First Coronavirus Response Act has been that the DOL recognizes that this is a very new law, and employers are really scrambling to do their best to comply with all its provisions in a very short period of time. And so what the DOL has done is it said that although the law was enacted on March 18th of 2020, and it took effect on April 1st, we are going to give employers a 30-day grace period where, as long as employers are trying to comply with the law in good faith by doing the best they can to give employees leave where leave is due, we are not going to strictly enforce or bring forth any action for violations of the law during a limited 30-day period, which runs from when the law was enacted on March 18th, 30 days until 30 days after that date. So that's something to keep in mind. And by no means is it a free pass for employers to, simply disregard the law. But it does give some peace of mind that as long as we're doing what we can to comply, the Department of Labor is not going to necessarily take a strict approach and come after us. So that's a good piece to keep in mind. And the DOL will also likely be releasing additional guidance as we continue forward on this specific provision, as they have been doing throughout the past week since the law was enacted. So with that, I'm going to pass the torch over to John Landesman to speak about some particular issues related to unemployment compensation benefits and how those interact with coronavirus.
Thank you, Mark. And for the next 20 minutes or so, we're going to take a tour of a number of issues. We're moving away from the FFCRA. And then, as I mentioned at the top of the hour, we're going to reserve 10 or 15 minutes at the end to address your questions. Although we see your questions as they're coming in, I encourage you to continue asking them. So what's new with unemployment compensation? As Mark mentioned, unemployment compensation is not available for employees who are receiving either paid sick time or paid family leave under the FFCRA. So when are the employees going to be eligible for unemployment compensation? Well, certainly if you shut down your facility or project, if you lay people off or you furlough them, that is going to render them eligible for unemployment comp. And by the way, we've used the term layoff and furlough throughout this presentation. And I have contractors asking me, what's the difference between the two? And generally, a lot of people are using them interchangeably and there's no difference. But to some extent, people are saying, and more technically, a furlough involves a period of time when the person is not working, but we continue to pay health insurance benefits. So that is usually the reason that people would use the term furlough as opposed to a temporary layoff, is the continuation of health insurance benefits. Under the CARES Act, the stimulus bill that was passed, there were some expansions to make more people eligible for unemployment compensation benefits than ordinarily would be eligible. Typically, if an employee is sick and is unavailable, unable to work, that person, under almost all state laws, is not entitled to unemployment compensation benefits. One of the tenets of unemployment compensation is that in order for the person to receive benefits, typically they need to be ready, willing, and available to go back to work or to get a job somewhere. CARES Act changed that for COVID-19 and essentially said that if someone is suffering from COVID-19, is sick, or if someone is taking care of an individual in their household who's sick, or if someone can't go to work because they suffer from a condition that affects their immunity system, they're immunocompromised because of chemotherapy or other reasons, they will be eligible for unemployment compensation now under these new rules. So we have to keep that in mind. A lot of jurisdictions have traditionally had 7-day waiting periods. Not all jurisdictions. For example, Maryland's never had one. Washington, D.C., they had one. Virginia had one. But now, in response to the COVID-19 pandemic, most states, including in Washington and Virginia, have done away with the 7-day waiting period. So when the people apply for unemployment comp, they get those benefits immediately. They don't have to have a week where they wait to receive the benefits. That's the good news for the employees. On the flip side, the good news for employers is that when there are UC claims that relate to COVID-19 really just about in any way, the states are saying that they are not going to charge the employer's UC accounts, which means essentially that your unemployment compensation tax rating won't be affected adversely. It won't increase as a result of these COVID-19 related claims. The other big news as far as unemployment compensation, and we'll look at it more carefully, I have some slides later on about the CARES Act and unemployment compensation, is that the individuals, in addition to receiving whatever they're eligible for under the state unemployment compensation benefits calculation, so that could be $500 a week, $550 a week, whatever the maximum is that they receive. On top of that, the federal government is going to provide a supplement of an additional $600. And so you've probably seen headlines. They call this, unemployment compensation on steroids, because the people are getting, in many cases, double the amount of unemployment compensation that they'd ordinarily be entitled to receive. And of course, this provision was something that was hotly contested, particularly in the Senate before it became law, because there was a question as to whether or not providing such a rich benefit, $1,100 or $1,200 per week, to an unemployment compensation claimant is a wise public policy, or does it incentivize people essentially to stay home and not go back to work. That debate, I guess, is sort of moot now, because the law is what it is on that. And the $600 per week supplement is part of the CARES Act that's now law. Will an employee be deemed eligible if he or she refuses to come to work simply because they're afraid? So we talked about there's expanded rules now, and the person can get unemployment comp for reasons that certainly go outside the ordinary rules. But if they just refuse to come to work because they're afraid, is that enough? And I don't want to discount that fear. I mean, there's a lot to be afraid of right now in the world. But if you're an employer and you are performing essential work and you have work that is available and the person just refuses because of fear, are they going to be deemed eligible? The answer is they shouldn't be deemed eligible. you would hope that the unemployment compensation authorities that are processing these claims in various states would say, no, that is not a good reason, or what a lot of states use is a necessitous and compelling standard, which is a fancy way of saying a good reason to refuse to come to work. Just the fact that there's the existence of the pandemic at large in society is not a good enough reason. Whereas if you've been specifically exposed at work, or if you're suffering from symptoms, those would be a necessitous compelling reason. Fear alone is not. And that sort of fits together with a concept under OSHA. OSHA, of course, being the federal law that deals with workplace standards. There are many standards that are specific for all different types of hazards. And there's also in OSHA a general duty clause that basically is a catch-all and says that employers are generally responsible to provide a safe working environment for all their employees. And there's a concept that judges have construed from that general duty clause to say that if there's an imminent threat in the workplace, an employee may justifiably say, no, I'm not coming to work. And so the question is the imminent threat defense or imminent threat assertion available to employees? Can they refuse to come to work just because they're afraid? And we haven't seen case law on this because it just hasn't been decided yet. It's too fresh of an issue. But we believe that courts and the administrative agencies will not allow employees to assert that imminent threat provision of OSHA merely because of the existence of COVID-19. Let's see. We have a question here from Gabriella Ginsburg. And the question is, what about partial unemployment if an employer reduces hours? Will they still receive the full $600, or will it be calculated based on reduced earnings? So if an employee's wages are cut to a certain extent, and these calculations vary by state law, they can, even though they're still employed, receive partial unemployment compensation benefits from the state. The question is, if they receive the small amounts, $150 a week, in partial UC benefits from the state, would they get the full $600 on top of that? And my understanding, and I'll also ask Marc this question, my understanding is that we were awaiting further guidance, definitive guidance, from the Department of Labor on issues like this. And we would assume that the people would not get the full $600 if they're only receiving partial benefits. But I don't think we have a definitive answer. Marc, have you seen anything? These rules are changing day by day. Have you seen anything on that specific issue?
That's right. I have not seen anything on the specific issue of partial unemployment, where an employee is still actively employed but has reduced hours. On the other hand, if an employee is no longer working at all, as long as he or she has been deemed eligible for any amount of benefits under the state law, he or she would be entitled to the full $600. But that's right, John. We're still waiting guidance on that partial benefit issue.
Thanks, Marc. All right, let's shift away from unemployment comps. We have a number of other topics. Let's talk about workers' compensation. So the District of Columbia Department of Labor has issued guidance talking about whether or not someone who's tested positive and has coronavirus can file and receive workers' compensation benefits. And the answer to that question is yes, but only if the employee can meet a very high threshold and prove and establish that the virus that they have was contracted at work or that it's job related. And so that would make typically to prove occupational disease cases as opposed to injury cases, it's a much, much more difficult task for claimants. And so we suspect that most COVID-19 related workers' comp cases are not going to be, unless there's really compelling evidence, those claim petitions will not be accepted. I want to say, though, that there is a movement in some states to change that rule of law, and this is an evolving issue. So, for example, I know that in New York last week, there was a state senator who introduced a bill that would modify New York's workers' compensation statute to say that if an employee contracts COVID-19 and they work in one of a number of specified industries, including in construction, there would be a presumption that the COVID-19 was work-related. So that would have basically turned the law on its head in New York, and I know that other states are looking at that issue also. So I guess we have to stay tuned on that as well. But right now, at least in the Washington area, we're not aware of any legislation that would that has been implemented on that issue. Let's move to the CARES Act, and specifically, I want to talk about the provisions of the CARES Act that establish a payroll protection program, a loan program for smaller businesses. There are other loans that are available for larger businesses with more than 500 employees, but these loans that we're talking about, the payroll protection program loans, I'll refer to them as PPP loans, they've really been receiving a lot of attention because they're forgivable if you meet certain circumstances, which is essentially a way of saying it's free money from the government if you qualify. So how much money is out there for this? Well, the stimulus program was about $2.5 trillion. 350 billion or 349 billion of that is designated for these PPP loans. And as I said, they're only for smaller businesses, small businesses being defined as a business with less than 500 employees. There's no test as far as the amounts of revenue or profit that the business generates, or a test regarding how much cash reserves. There's really no underwriting that goes into these loans at all. There's no personal guarantees. They're waiving all the fees. I mean, this is something that is an incredible benefit for small businesses. Really, every business that's on the phone with us today should at least explore the possibility of this program, because, like I said, it's essentially free money. All that is required on this relatively short loan application is a certification that COVID-19 is impacting your business. And what business really on the face of planet Earth couldn't say that at this point? So the loans are going to be available, and the last date to apply is June 30th, although it's only to the extent that $349 billion is not all used up. And there is such a rush in terms of the number of applications that people are concerned that the money will be all used up. And the money is primarily directed and loaned to contractors or other businesses so they can pay their payrolls for a fixed period of time, and we'll talk about that period of time, as well as health insurance, 401k, and other fringe benefits. And when we're talking about the salary that you can use to fund when you're using these PPP loans, that's capped at $100,000 prorated annually. So how much of a loan would your business be entitled to? So it's the lesser of 2.5 times your average monthly payroll cost. So if your monthly payroll cost is $1 million a month, 2.5 times that a $2.5 million loan would be the max that you could apply for, or $10 million. That's that's the cap on the amount of the loan. And again, when you're calculating the payroll and doing that calculation, you have to cap everyone at a $100,000 salary annually. What can you use the loan proceeds for? So it's not only payroll costs and fringe benefits, but you can see rent, utilities, interest on debt obligations. Items 5 through 7 there on that slide cannot account for more than 25% of what you're using the loan proceeds for in aggregate. So I said that the loan is forgivable if you meet certain criteria. What are the criteria? Well, in a nutshell, you need to not lay people off or reduce your headcount. And to the extent that you reduce your headcount, that proportionately reduces the amount of the loan that is forgivable. And you can see there's a slide that talks about the exact calculation of how the loan forgiveness is affected by laying people off. And then the second situation that can impact the loan forgiveness amount is if you have an individual employee whose salary is cut by more than 25%. Doing that can also have an incremental impact on the amount of the payroll of the PPP forgiveness amount. Let's talk about now the CARES Act unemployment compensation provisions, and I want to get through this relatively quickly because we do have a number of questions. I think I had already hit most of these highlights. The extension of unemployment compensation from 26 weeks to 39 weeks, essentially taking it from 6 months to 9 months. The additional $600 per week supplement, which, by the way, is only going to be provided through the end of July. So it's not like the people, at least as of right now, unless that's changed, are going to get that $600 supplement for the entirety of the 39 weeks. The unemployment comp, again, we sort of went through that. Let's talk about some general questions or FAQs that we have identified simply by the number of contractors that are calling Marc and I and the other members of our labor and employment group at Cohen Seglias. We're seeing these questions repeatedly. So we pick them and we hope that they're helpful to you. Marc, were you trying to jump in there? I'm sorry.
Sure, I can do that.
Yes, please go ahead.
Sure. So, and I'll just take control of the slides here. Sure, thank you. So there are certainly a number of concerns that are going on with contractors and employers all over the place with respect to layoffs. Number one being that if an employer needs to implement layoffs or even a furlough that, which John mentioned earlier, there are already concerns that you always face with a layoff or a furlough, and that is you want to make sure that in any situation where you're laying off or determining who in particular needs to be laid off as part of your workforce, you want to make sure that you're not giving rise to any potential claims for discrimination. And that applies either in this current situation with coronavirus or otherwise. And when you're looking at that, you really want to make sure and watch out for age discrimination claims in particular. And to do so, a good practice is to consider, seniority, but you also want to take a look at other objective factors if you can, based upon performance and other issues. And you want to make sure that you're not grouping together, let's say, all of your older employees and getting rid of all of them just because they're the most senior. And you also want to make sure, for instance, that you're not grouping together all minority employees or members of another protected group and laying them all off. You want to make sure that you are essentially using objective criteria and making your decisions across the board. With respect to enforcement of non-competition agreements for employees and mostly highly compensated individuals, many of them may have non-compete agreements with your company if you have those. And for those employees, if they're laid off due to this situation, there is a concern that in those particular instances, a court may be less likely to enforce the non-compete because the employee was laid off and they did not voluntarily leave to go seek employment elsewhere. And that's also the case, even putting aside coronavirus, where an employee is either terminated or laid off by his or her employer. Courts are in general less inclined to enforce or strictly enforce non-compete agreements. In terms of the CARES Act and the Paycheck Protection Program, John already touched upon this, but one of the main concerns for employers is that if we lay off, one individual or more after we've already applied for and received loan proceeds under the Paycheck Protection Program, that would potentially reduce the amount of loan forgiveness that we can receive from the government, and we could be on the hook for some of the proceeds that we receive. And so that's something to keep in mind. And if you are applying for or you've already been approved for the Paycheck Protection Program, to the extent possible, and so you get as much loan forgiveness as possible, you should look to keep employees on your roster.
Right. And Mark, before we go to that next slide, we've
Sure.
got a question from one of our participants. Which law regulation applies? Is it where, and this is for unemployment compensation, is it where the employee physically works or where the company is headquartered or the state in which the employee lives? And generally, we're paying in unemployment compensation where the employee is working. So if we have a company that has, it's a contractor that has its headquarters in Delaware, but has a project going on in Virginia, the remittances for unemployment purposes are going to be in Virginia, and that's where the person would get their benefits paid from. Now, there's exceptions to that. Some states are a little funny about it, but that's the general rule there.
Right.
So why don't we give, I'm sorry, go ahead, Marc.
No, that's okay. And so I was going to speak generally about the WARN Act, which we referenced earlier. And as you know, the WARN Act is a federal law that applies to situations where employers implement what's called a mass layoff or also a plant closing. And it does not apply to just any layoff. Under the WARN Act, it only applies to layoffs that impact at least 500 employees at a given site of the employer or at least 50 employees at a given site, so long as those 50 employees also make up at least 1/3 of the total workforce at the site. So there are certain thresholds there, certainly. And if, for instance, if you're just laying off a few employees, WARN would not be triggered. And also an important thing to keep in mind with WARN is that if an employer is laying off employees for less than 6 months, those layoffs are generally also not going to trigger WARN because they're considered temporary. And so we're looking at layoffs that not only satisfy the first criteria of the correct number of employees, but also ones that last more than 6 months or more. And with respect to coronavirus in particular, there are certainly some exceptions under the federal WARN Act, which courts are going to have to interpret after all this unfolds. And in particular, there's an exception in the federal WARN Act for situations where there is a natural disaster and also an exception for unforeseen business circumstances. Now, federal courts and also the Federal Department of Labor have yet to give clear-cut guidance on whether or not those exceptions apply to coronavirus in particular, but there is a good argument that they should at least apply in some respects. And so those issues remain to be seen how they come out at the end of the day. But employers should look to those exceptions when considering if WARN Act notices are required.
Mark, I'm going to jump in for a second,
Sure.
and we've got about 5 minutes left. To the extent that any of the participants, and I know everybody is still on the line here, if you have questions about any of the material or any other issues, please feel free to submit them using the question box. Mark, I'll let you get back to the state WARN requirements that are out there.
Sure. So, in particular, with respect to Washington, D.C. and Virginia, those two jurisdictions simply follow and are subject to the federal WARN Act. They do not have any local, for purposes of D.C., or state law for purposes of Virginia that would modify those requirements that we discussed in our last slide. On the other hand, Maryland does have what's called a mini WARN Act, which the statute is actually called the Economic Stabilization Act, and which this act applies only to employers that are in the industrial, commercial, and business industries, and who also have at least 50 employees. So arguably, and in most contexts, construction industry employers and contractors would be falling under this provision because they would either fall under the industrial or commercial aspect of the law, provided that they also have at least 50 employees. An important point to keep in mind, however, is that Maryland's mini WARN Act is essentially voluntary, which is strange from the perspective of most laws, but really what the Maryland mini WARN Act is designed to do is to encourage employers to provide at least 90 days advance notice and paid benefits to employees when the WARN requirement notices are triggered. But once again, employers are not required to do so.
Thank you. I'm going to go over this additional information real quickly, and then I think we're going to wrap up. Can you require that employees disclose positive tests, or is that some sort of a HIPAA violation? The answer is we can require it. Can we send people home if they exhibit flu-like symptoms, or we see someone with excessive perspiration or who's coughing? The answer is yes. Can we go so far as to take employees' temperatures? So everybody shows up at work, we have a toolbox chat or some sort of quick meeting, and we take everyone's temperature. Are we allowed to do that? EEOC has answered the question. Generally, yes, we can do that. It's not a privacy violation or any sort of unlawful medical examination. If someone tests positive, do we want to make disclosures to our subs, to others on the project site, to our employees? Yes. Do we want to disclose specific names of the employee when doing so? No. If at all possible, we want to avoid the specific names when making those disclosures. I guess the other thing I'd note is that you want to notify if there is someone who's tested positive at a site or in your offices, not only the employees, but also the CDC and your Department of Health. I've got a final slide here, again, with our photographs, but more importantly, with our contact information. You can see there, because we're during this time, both and all of our attorneys are working remotely. We've listed our cell phone numbers there. To the extent that you have questions that we did not get to, and if you would like to reach out to one or both of us, feel free to contact us by email or give us a call, and we will answer those questions. So with that, I want to thank everyone for participating. I want to thank the Washington Building Congress for organizing this event, and I hope that it was helpful to everyone. And I hope that everyone stays safe this weekend and has a good weekend. Marc?
Yeah, so I just wanted to thank everybody as well, and I hope everybody has a nice holiday and stays safe and has a great weekend.
Okay. Thanks very much, everybody. We're going to sign off now.